Good morning, this is Alex Woods here, financial mis-selling litigator, and I'm going to talk to you about a very important judgment that's been handed down by the Court of Appeal on 16th of December last week. And I'm going to aim this one principally at fellow professionals, but I hope to keep it broad enough such that not just lawyers, claims management companies, bankers, others will find it of value, but also to keep it something of a legal light presentation so that those who simply may have a complex payment protection insurance claim themselves that they are currently grappling with can find something useful in this video posting. So I'm going to cover first the facts of the case, its Court of Appeal decision. I'm then going to look at the legal issues that arise and do something of an analysis. Then I'm going to go on to the a explanation or a examination of the way in which a big bank operates when it comes to defending and protecting its legal position in the courts for commercial benefit. Hang on for that section of the posting because that's really fascinating. And then I'm going to conclude with the general principles that can be derived from this particular judgment and what are likely to be the next steps in terms of the procedure, in terms of this particular piece of litigation, because things very rarely stand still in English law, they're nearly always evolving. Okay, so the first thing to say is that this is a Court of Appeal decision, and two different appeals have been co-joined in legalese. On the one hand, a lady called Mrs. Conlon, who brought a claim for missold payment protection insurance against the bank, in this case a Black Horse, and on the other hand a broker type mis-selling PPI claim in which the appellant here, Mrs. Plevin, brought a claim against initially the broker LLP who arranged the transaction, but subsequently that broker, as has so often been proved to be true during the course of the recession, went into liquidation. The question then being, could she successfully sue the underlying bank, subprime bank, in this case Paragon, and the underlying insurer of the payment protection insurance policy, even where that underlying insurer, in its own words, shouldn't be held culpable for the dodginess of this particular broker that have gone into liquidation. So those are the facts of the two cases, and they raise a general big question over the interpretation and the implementation of the unfair relationships test. And if you take nothing else from this one video posting, it is that this judgment, this Court of Appeal judgment, heard on 6th of December 2013, last week, is pretty significant. I'm hesitating to use the word seismic because I've used it in a video posting before, but it is something of a seismic decision by the Court of Appeal, in so far as it has, if you like, floated the possibility of the unfair relationships test, which was brought in by the Consumer Credit Act 2006, amending the Consumer Credit Act 1974, as its own tool, its own legal instrument that can be used by consumers to hold big financial institutions to account. Previously, as a result of a judgment called Harrison and Black Horse, the same financial flunkies as has been joined in this particular appeal, previously the court had decided that providing the bank had complied with its rule book, the Insurance Conduct of Business Rules, then there couldn't be an unfair relationship in broad terms. This Court of Appeal judgment seriously questions, doesn't quite overturn, I'll come on to the facts of the case shortly, seriously questions whether or not that was the right judgment. So anyway, those are the facts of the two cases, and as I say, I've alluded to the point of principle that those facts were bringing out. I mean, just to tell you briefly about the two cases, Mrs. Conlon had basically taken out she consolidated two loans, taken out a certain sum of money. She'd only wanted £1,500 of an additional loan. Black Horse consolidated old loans, you see, and they stuck on a £3,500 parent protection insurance policy. And when you start to drill down to the circumstances of the case, as was found by the judge at first instance, you know, it is a scandalous missale, and no other word can be used to describe it, and a word which has been used by the Court of Appeal judges in this judgment that I've got here: unfair. Clearly unfair. And also the issues of causation were raised, because in the Harrison case it was said that even though the Black Horse hadn't disclosed the amount of commission that they were getting from the sale of the insurance, in the Black Horse and Harrison case it was 87%. It's much lower in this case, only 40%. But the point isn't the cost of it. The point is the transparency on behalf of the bank. So, and also whether or not it's actually caused any unfairness, and whether or not it's appropriate for the court then to act on that unfairness by making an appropriate order. The court found that in Harrison, it wasn't appropriate to make a ruling of unfairness and to take steps to make some order to force the banks to pay back the payment protection insurance. In this, it's clearly unfair. She was a nurse, and there are also certain features of the case. The judge at first instance found that if she had been told about the fact that Black Horse were taking 40% of commission, she would have shopped around elsewhere. So there was no lack of causation, if you like, in the transaction. So the facts between the set of facts between the two cases are materially different, and the sets of facts in this particular case is what have caused the judges to question the previous decision by the judge in Harrison and Black Horse as to whether or not, simply by applying the rules and proving that you're in compliance as a bank, that absolves you of any unfairness. No, said the Court of Appeal judges in this appeal, it didn't. And the second case is also important in establishing the broad scope of the unfair relationships test, because that dealt with the issue of whether or not a particular clause in the unfair relationship tests on behalf of could be applied in a broad sense here, such that, as I've said, the lender can be held culpable for the unfairness of the transaction even after there's no longer a broker on the scene. Can the underlying lender, who may not have been involved in the transaction, be held culpable? Once again, the decision in this judgment was yes. So I'm just going to now go into the legal issues, and this is directed at lawyers perhaps more than it is the layman, that arise out of these two co-joined appeals, and the individual issue that arose in these two quite distinct issues, although they were shared a general similarity in terms of the application of and the breadth of the unfair relationships test rules. I'm going to drill down into two of the issues that the court considered, which will throw light on the bigger issue, I'm sure. The first thing to say, it's very interesting, the Plevin and the Paragon case, is that in the leading judgment, it is said that, you know, we find that in this case, Paragon were responsible for the manifest failings in the sale of the payment protection insurance by the broker, even though hypothetically the broker might have gone to a different lender after it had made the sale. It said that you have to look at the sort of totality of the parties on what was described as the creditor side of the relationship, of which not just this broker LLP went into liquidation sat, but also Paragon and potentially other people, the underlying insurer, sat. And the court is allowed to look at the entirety of all those relationships to see to what extent the actions of those parties contributed to the unfairness. And the court is entitled to make a finding of unfairness as a result of this melange on the creditor side of parties involved in constructing the opportunity perhaps for a product to be a financial product to be missold, and then can find an individual, any one of those individual parties culpable and make an order accordingly. So that's the this, you can see that there's quite a breadth to the Court of Appeals findings on the, you know, the scope, the wide-ranging scope of the unfair relationships test. The other interesting thing, though, by conversely, and in making that finding, the Court of Appeal found that even though the Court of Appeal found that Paragon, strictly speaking, in terms of the rules, and it refers to this rule 1.2.32 of ICOB, this rule says that where there is a chain of insurance intermediaries between the insurer and the customer, ICOB applies only to the insurance intermediary in contact with the customer. So Paragon was saying, well, look, we've complied with the rules with ICOB. We weren't in direct contact with the customer. Because the principle in the previous judgment of Harrison and Blackhall said that it would be anomalous, was the word that was used, if a lender who was non-compliant with the ICOB rules should have a finding of unfairness under the unfair relationships test made against them. It said that's, you know, that's it's anomalous to have the rules saying they didn't do anything wrong and the law saying that they did do something wrong. However, the judges found in this case that there was unfairness, even though, strictly speaking, Paragon were in compliance with the Insurance Code of Business rules. Perhaps rather a scary prospect going forward for financial institutions. But again, if you're a financial institution and you've got a moral code informing your business and some sort of an ethical code informing your business, and this is perhaps an opportunity for ethical banks going forward, and you've got ethics built into the way you operate, this, but by the same token, the judge specifically referred to an example where a lender could be non-compliant with the rules, with its business code of conduct rules, and yet the court may find that the relationship wasn't unfair, or even if there was some fairness, that particular financial institution shouldn't be held liable because they've done everything right. So that is quite an interesting point in the Plevin and Paragon part of this co-joined appeal, in that the courts found that, you know, the financial institutions have to look beyond compliance with the technical details of the rules, with the letter of the law, or in this case the letter of the regulator, to, you know, principle. Scary for some people, but not so scary who just simply want to make sure that they've ticked all the appropriate boxes and filled in the paperwork. Not so scary for people who put ethics, morals, financial responsibility, proper professionalism at the heart of what they do as financial institutions. And I personally am encouraged by this part of this Court of Appeal judgment. So that's the issue, and just to conclude on that issue, the court considered a narrow interpretation, if you're a lawyer, of on behalf of in section 140 of the Consumer Credit Act, whether because the bank's lawyers argued that a narrow interpretation preferred, it considered a narrow, strictly legal interpretation, legal liability interpretation of that expression on behalf of. It decided that no, a wider interpretation of what on behalf of meant should be preferred, and in this case a broker LLP acting on behalf of Paragon, the lender, meant that the lender could be held responsible. But it also went on to say that even if it had preferred a narrower interpretation of on behalf of relating strictly to legal liability, then it still would have made the same finding. So the court was trying to close off the door against any lenders thinking that they could get away with the broker doing all the dodginess and them hiding in the shadows, which puts a slight slant on it. If you're a consumer credit lawyer like me, you unfortunately you're going to have a slant against the banks. So the second issue that was considered, that I'm going to consider, and was considered in relation to the Conlon and Black Horse case, was, I mean, make no mistake, this the Court of Appeal decision that I've got here dismissed Mrs. Conlon's appeal. She lost. But in dismissing it, the court felt that, well, the court expressed in no uncertain terms its disappointment with the fact that it felt itself to be handcuffed in dismissing the appeal. And I'll just explain. So Harrison and Black Horse had concluded that providing you're compliant with ICOB, the rule book, the business rule book laid down by the regulator, then it would be inappropriate to make a finding of unfairness. In Harrison, the facts of the case were such that, and Tomlinson, the judge in that case, said it's not appropriate to respond with to go with some visceral instinct that a sale is beyond the pale purely because it's so expensive. This person would have taken the insurance anyway. I don't think there's I can't be making a finding of unfairness here. So the facts there were a certain set of facts that led to that conclusion, and I sympathise with it. I've always thought that that was a right judgment in those facts, that just because an insurance product is very expensive, a lot of people wouldn't mind that. They may be looking simply at their monthly repayments. They may be reassured that Lloyd's, Black Horse, a reputable institution, are behind the transaction. It's not a broker-lender relationship where you're trusting that the broker in front of you is going to assess your circumstances, your own particular circumstances, and then go into the marketplace and choose the best deal. That's not the nature of the transaction. Those weren't the facts in Harrison and Black Horse. Here, as I've alluded to earlier, the facts were different, and in the circumstances, and the most particularly and most important evidential finding that came out of Conlon and Black Horse was that was an internal policy document in which Black Horse have said we're taking a policy to non-disclose because we know that if we reveal how much money we're making from this payment protection insurance, none of our consumers will buy it and they will all go elsewhere. So they were deliberately concealing and withholding important key, the judge in this case decided key information, because he decided that the consumer would have gone elsewhere even though the commission was only 40%. The bank is deliberately holding important information that will enable it that will make the transaction transparent in order to further its own commercial interests. And when you look at it that way, all three judges said one of them said he was dispirited, another one said it was unfortunate, but nevertheless they felt that they had no choice but to dismiss the appeal, because they had their own court, the Court of Appeal, in Harrison had laid down a judgment that they felt that they had to comply with. The issue that was up for discussion in Conlon and Black Horse here was, you know, as you can imagine, the lawyers for Mrs. Conlon tried to persuade the court that this particular case, the facts of this case, distinguished it from the Harrison and Black Horse case. But the three Court of Appeal judges decided that, unfortunately, as far as they were concerned, exactly the same issue was being addressed here as had been addressed and decided in Harrison and Black Horse, which was, if you're in compliance with ICOB, it would be inappropriate to make a finding of unfairness and make an order under the unfair relationships test. So those are the two. Those were the issues that were argued, and those were the conclusions that the Court of Appeal judges arrived at in both. Now I'm going to come on to the fourth section, which is, I think it's quite interesting. This is quite an interesting window into the way that a big bank operates and the way in which it marshals its lawyers, a battery of lawyers, to protect and advance its own interests. What's so interesting about this is the chronology of events. This particular case, the Conlon one I'm talking about now, was actually decided at first instance by the first judge when it first came to court back in, I think, early 2011. You then had the banks then appealed that decision, Black Horse, the same bank. But I wonder whether or not they didn't leave that one as a low priority in order that they could first appeal Harrison and Black Horse, because the Harrison and Black Horse appeal was heard in, I think, November of 2011. So you have Conlon decided at first instance early 2011. You then have Harrison decided in late 2011, and a Court of Appeal binding judgment given about this principle. And then in November 2012, you have a High Court appeal in Conlon, which has to go with the Harrison appeal, which is already been made, finding which has already been made, and then you have appeal from the High Court to the Court of Appeal from Conlon. So even though kind of in a way, I think what I'm saying is that the banks strategically played this very well insofar as they got Harrison decided before they got Conlon decided. If Conlon had been decided and gone up to the Court of Appeal and some sort of binding judgment had been handed down, some sort of precedent had been made, then Harrison might have been quite a different finding in Harrison. One shouldn't be surprised, and there's no point in getting upset about it, by a big financial institution which is out and out protecting its own commercial interests and putting as much money as they need to into this whole exercise has made lawyers very wealthy. In the case of Paragon, the bill was something like Plevin and Paragon. The bill was something like £320,000. Ridiculous, a legal bill for a tiny little PPI case. Nevertheless, there are important decisions, important legal precedents that need to be decided for the benefit of the consumers and the world in general. You can see how a big financial institution is protecting its own interests when you look at these judgments in really quite a cold and calculated fashion. And you look at the points that they argue; they're often taking points which have merits in argument, but when you stand back and look at them, don't have proper weight or substance. So there it is, and in the Harrison and Black Horse case, there was never the opportunity for the Supreme Court to decide. I'm now going to move on to my conclusion. and wrap things up by addressing the broader principle and by addressing the procedure in this case. This case, Mrs. Conlon's had her appeal dismissed. Plevin and Paragon, fine. That's done, and that will be remitted to back to the courts, and Paragon will lose. But Conlon and Black Horse, so Mrs. Conlon's had her appeal dismissed. The judges have said that they would love for this case now to go up to the Supreme Court for clarification. But will it go up there? I very much doubt it, because the banks, having heard what all three judges have said about the manifest unfairness in the way in which this product was missold, are hardly likely to risk creating a binding Supreme Court precedent that will cement the principle and enshrine the principle of fairness in the consumer credit law, and make it very difficult for them to run their businesses and then to sell more dodgy products down the track, or sell non-dodgy products in dodgy ways. So this will be settled. Black Horse, I hope I'm not made to eat my words. I'd be very surprised if Black Horse let this get to the Supreme Court. They will pay Mrs. Conlon, and Mrs. Conlon can ask her what she wants, as can her lawyers, because Black Horse will not let this get to the Supreme Court. There may be a twist in the tail. I don't know the relationship, the facts between Mrs. Conlon and her lawyers, but it's unlikely that Mrs. Conlon is going to turn down a large amount of money simply because simply on the basis that she wants a legal precedent set that's going to benefit other consumers. She can't. So it's unlikely that this case will go any further, and indeed in Harrison and Black Horse, once again it never got to the Supreme Court because the banks paid him off. So finally, to conclude, nevertheless, I don't think anybody should be under any illusions, and I will refer back to transparency at all levels. And if you're a consumer credit lawyer, if you're a claims management company, if you're a bank, if you're someone who's been got a claim against the banks, you know, the issue is transparency. That's one of the biggest issues here. Time and time again, you see it coming out in the attitude that the courts have towards these types of cases. They don't like it where there's a lack of transparency in a financial transaction between a powerful financial institution and a poor little old consumer. I think Mrs. Plevin was a poor little old consumer, sort of in retirement age. They don't like it. So even though we've not got a judgment to waive at the banks, if you're talking as a consumer credit lawyer representing consumers, that is, we do have plenty enough material to frighten them from challenging to trial cases brought on behalf of consumers where there has been a manifest lack of transparency, even where, and there's been unfairness, even where the lender has complied with the strict letter of its own guidance. It's going to expand the breadth of this unfair relationships test and its applicability rather than narrow it. Well, that's all for now, and I hope you enjoyed and found that video posting informative and helpful, and I look forward to posting you in due course in the new year. Goodbye for now.